and I gotta find out what the Marco diddly words are. I'm gonna stop by. Oh, you got a hat.
Well, I've got my hard hat on.
People throwing stuff at you?
That's what this real estate market's doing to us these days.
I had a
But
full
I'm
head
ready
of
for
hair.
you guys. All right, so I've got my tools. I hope you guys will have your tools. Let's use today's class to kind of go through an offer. And this, we're going to go through it in a little different way than what I've seen other people present on. I actually watched there have been several NABOR classes. And the one that I was told about last night, which I did watch, it was hosted by a friend of mine, Sean Gary, who's an attorney with Gray Robinson, I believe.
Mhm.
So I'm going to make sure I turn off all the volume on this, but I am going to share my screen on this. I would say if you guys haven't watched one of the videos on the forms, this is a good one to watch. I thought Sean did an incredible job. He was very specific on what changed, what didn't. There he is up in the corner there. And he went over every little change and why the change was there. Now, he stopped short of actually giving advice on the forums. That's our job, Dad. That's what we're good at. We're going to give advice. We're going to actually give you strategy, how to, a way you could do it, right? You ready for that, Dad?
Huh? Sure.
Of course you are. Of course you are. All right. So John's video is called NABOR Contract Changes NAR Settlement. This was posted 6 days ago. It's already got over 800 views. Honestly, he did a great job. I watched 52 minutes of another attorney talking. I deserve an award. I've never done that before. So
where is this posted, Christian?
it's on YouTube, where all of our videos are posted as well. But this is under the NABOR YouTube site. It's called the NABOR Contract Changes NAR Settlement. You know what I'll do? I will post this because I actually texted Sean last night and told him that I did enjoy the video. Please don't tell him that I didn't watch the whole thing. All right, I just posted it. I will watch the whole thing. Here's what I did really, really like that he did. Let me see if I can share my screen. Oh, I still am. Okay, that's good. So he mentioned looking at the NAR settlement FAQs. Honestly, I think everyone needs to read these because it's going to answer, I don't know, at least half of your questions, if not more. And so that you can download the PDF in English or Spanish, or you can simply go down through this. Who's covered? What's changing? What are the dates? Offers of compensation. Does this mean buyers won't have to use a buyer broker to purchase property? Like all the questions that we've had over the last few months, really helpful. And what we're going to get into is the written listing agreements and the written buyer agreements. Let's start with number 55. I thought this was great. What provisions must be included in written buyer agreements? All right, so there are multiple written buyer agreements that you can use. We talked last week about hook agreements versus no hook agreements. The hook agreement is essentially something that binds your buyer to you, that is legally enforceable. A no hook agreement is something that the buyer could simply terminate unilaterally. That's kind of how that comes from. But they say the written agreement must include, 1, a specific and conspicuous disclosure of the amount or rate of compensation the realtor will receive or how this amount will be determined to the extent that the participant will receive compensation from any source. So AKA has to be specific, 3% of the purchase price, or a $10,000 flat fee, or whatever it may be, has to be specific. Number 2, the amount of compensation in a manner that is objectively ascertainable and not open-ended. Therefore, you cannot say whatever the listing agent is offering or whatever bonuses the builder is offering. You can't put that. It has to be specific, conspicuous, and objectively ascertainable and not open-ended. All right, 3, a term that prohibits the participant from receiving compensation for brokerage services from any source that exceeds the amount. It's basically, if we agree to 3%, I can't then collect 4% unless we amend the agreement or do something beyond that. A conspicuous statement that broker fees and commissions are not set by law and are fully negotiable. So that's it. They're really, you would think you could probably make this into a 1-page agreement. Well, guess what? You kind of can. You kind of can. I will give you a disclosure. Warning, warning, warning. I'm not your broker. I have no control over your broker, even if you think I might. These are just our opinions. Your broker is the one that pays you, not me. They matter. In fact, I got my head cut off a little bit. It grew back quickly, so I'm okay. But one of the brokers in town called me and said, "Why did you say that to my agent? We're not doing it that way." I said, "Well, I did say to contact the broker." She goes, "Yes, thank you. I appreciate that." So whatever advice you get from an attorney, whatever you get advice from me, you really do then have to go make sure that it's going to be acceptable to your broker. And maybe you ask me first, I say, yes, that's acceptable, and here's why. And then you have a little more firepower to go and talk to your broker about it. That sound about right, Deb?
Yes.
Yes. All right. So we looked at that conspicuous, the 4 things that every buyer broker agreement needs. This agreement kind of does that. This is what I would call a no-hook agreement. It is published by FAR. It is a brand new form. It is called the Property Pre-Touring Agreement. So if you want to work with your buyer and be in compliance with the NAR settlement, this is good enough. It is 1 page. It is signed by your customer. It is signed by your broker or you if you're permitted to do so. And it lays out the 4 things that we need. It says how much you would be paid, a flat fee, a percentage of the gross purchase price, plus maybe a transaction fee or other. You put it in there. If you wish to work with buyer or broker to purchase property, broker may ask you to sign a separate agreement detailing the parties' responsibilities during the sale. That could be an exclusive buyer brokerage agreement at that time. A seller listing broker may agree to put some or all the above may agree to pay some or all the above compensation. So they're letting you know, hey, the seller or the listing broker may pay this, not the buyer. If a seller listing broker agrees to pay the broker for services broker performs for you, broker will reduce the amount you owe accordingly. Down here, if you choose a property already listed by broker, seller may pay broker for services broker performed for seller, and you will not be responsible for this compensation. And then the important one, broker compensation from any source will not exceed the amount of compensation in a written agreement with you. It kind of hits all the points in that FAQ. It really does. So in my mind, this seems like it would satisfy the NAR settlement. The question you have is, will your broker require you to then sign an exclusive buyer brokerage agreement that outlines services rendered and obligations and transactional broker or single agent? The exclusive buyer brokerage agreements are more extensive, more to them. What do you think of this form, Dad?
I like it. I think it's extremely elegant. I think it hits all 4 points in the frequently asked questions. It's a much easier way to get somebody that you've just met, that you haven't had an opportunity to build trust with yet, to go looking at properties, on a Saturday morning. So I like it. I mean, the whole thing is predicated upon the client deciding to go forward with you. You're giving him essentially the right to terminate.
You give them the right to terminate. You're not obligating the buyer to anything. Obviously, if you relied entirely on this, you are taking a little bit of risk. This is somewhat risky of a deal. Dad, you and I were talking about this, and one of our issues with it is that it's voidable, maybe, right?
Well, there's contract issues. There's also language in the settlement agreement that, if NAR or the plaintiff's attorneys perceives that we've come up with something that is a workaround that you reserve the right to come after and enforce, the lawsuit against whoever did it. So, that's the element of risk that's always with any form that anybody comes up. But the thing I like about this form was it's a FAR form. So
Yeah.
a massive team of lawyers who are hired to protect realtors came up with it after reviewing the settlement agreement. So if we can't rely on them, then who are we relying on?
Yeah, I think it's a pretty good form. It's one page. People were asking for this. They wanted something simple. They wanted something that wouldn't scare a buyer away. If you need that, use it. Now, let's assume that that form isn't your favorite form. It's a good form. It's not my favorite form. So let's go over what my favorite form is first, and then we will kind of work through a deal. And then I'll give you some sort of plan Bs in the event a buyer gave you a hard time on something. So I'm going to share my screen again. Let's see. Christina asked a question. Are you saying that exclusive buyer brokerage agreements are not voidable? Yeah, that's what I'm saying. So what I mean by voidable, and it's a great question, Christina, thank you. What I mean by voidable is that the buyer could claim that it was never a valid contract, that they could unilaterally void the contract as it was never had mutual consideration. That's the biggest concern. But more realistically, what I'm worried about is not whether a buyer can void it, because that's kind of what right I want to give the buyer. I want them to have the ability to terminate unilaterally, because otherwise they may not sign it. What I really want, what that form does, in my mind, is that it brings you into compliance with NAR. So if you sign that, you put a number on there, and then you can start going and showing properties. And depending on your broker and depending on how the environment goes, that might be the only form you ever have to use. But keep in mind, the buyer could always walk away from it. You cannot obligate a buyer to pay you based on that document alone.
We touched on this before, Christian, but another workaround with that particular form, the exclusive buyer brokers agreement, is have the compensation be either $0 or $100. As an attorney, I kind of like the $100.
Yeah. So let's look at that. So to me, this is plan A. I meet a potential customer. This person says, hey, I'd really love to see some properties here in town. Can you show me this weekend? You say, great, I love that. Where do you want to look? You kind of start to get to know each other. Well, before you actually go show a property, you do need something signed with the buyer that sets out those 4 things as shown on this number 55, these 4 things. That's what it has to have at a minimum. Well, in my mind, plan A, get them to sign a buyer broker agreement exclusive. NABOR, we're going to look at that one, but FAR has one as well. That's perfectly fine. It has a couple of little distinctions, but it's fine. I have no problem with it. You're going to fill this out. You're going to, the default is transaction broker, but you potentially could choose single agent or no brokerage relationship at all. It's going to reference what the buyer's role is, the term of the agreement. I think by default, it's going to be 180 days. That's fine. More is better in my mind. I would say 365 days would be great, a 1-year term. If during the blank period it terminates, there is a protection period on there. Number 5, this is the big part. This is where all the questions are coming from. What do I fill in? What I would say, again, we're going to look at plan A, plan B, plan C. Plan A, you put in what you owe, what you charge. So maybe you charge 3%, maybe you charge 2.5%, maybe you charge 10%. Whatever commissions are fully negotiable and not set by law. So whatever you and your buyer agree to, that's what you can put in there. You put a percentage. Now, keep in mind, you cannot accept more than that unless you later amend this agreement. So keep that in mind. I would say have a plan A. What's your go-to, what your charge is? I mean, Dad, you and we're asked all the time, what do you charge? We have to have an answer.
I always come back to
There's an
$5.
answer.
Yeah, there's an answer.
there's an answer. So have a number or have a fee based on the information that you gathered from them on your kind of like initial conversations and put it in there. They also have one for the rental potential. So you put that there. Scope, number 6. I have a couple of scenarios for you on this. I would say you want it as broad as possible. Now, I think NABOR did you a disservice on this form because it says this agreement is only acceptable or applicable to residential real property located in the following counties in Florida. If left blank, then Collier, Lee, and Charlotte. So if you don't put something, you're only going to be, limited to those 3 counties. The buyer could just, basically not pay you if they wanted to go over to Miami. I would put all counties. That's what I would put. I just put the whole state, state of Florida, whatever. Let's not be silly. Just put it in there. Nobody's going to fight you. Honestly, if they want to end up in, Anna Maria Island or something, then you'll wish them well and you'll tear up the agreement, right? Maybe that's outside of your go-to. We looked at this default language before in a previous video, but this is the part that people usually object to. Right. But again, plan A is you want to have remedies in the event the buyer doesn't pay you. That's the whole point of using this form. It's why it is your plan A. We like this plan. If the buyer doesn't pay you, you can sue them. You can put a lien on their house, things like that. Let's see, there's a couple other little check boxes. You can put terms in the, other terms and conditions. Keep in mind, if you're signing this and not the broker, you may need to confirm with them as to whether you're allowed to put anything in there. For example, Downing Fry says, hey, we welcome you to sign the buyer brokerage agreement, but we don't want you to put anything in the other terms and conditions. If you do, it then has to go to the broker for their signature. So I think that's the rule. It could change, and your broker might be a little different than that. It is 3 pages. Honestly, not that big of a deal, but and I like it. It is the best form we have. It protects you as the agent for putting all this effort into it from a buyer saying, I don't want to pay you. It's kind of the best option. Let's look quickly at the FAR one. Dad, any initial thoughts on that?
I like the longer one because it gives the scope of duties. You get people coming from other states and they're used to their realtor doing different things than they do here in Florida.
Yeah,
so,
yeah.
And it benefits the realtor in that they have to turn over any leads to you.
Yeah.
To work exclusively with you.
Exactly. If you didn't want to use NABOR, if you're more of a, Lee County or Charlotte County person, the FAR form is great. I have no problem with the FAR form. It has a lot of the same stuff. Keep in mind, number 3 here, it does have a place where you can put specific property addresses. Again, by default, I would just leave it open-ended. I'd say all of Florida and keep it that simple. But I did have a scenario. Someone asked me this morning, hey, I have an investor client, been a great client for a long time, but sometimes he does deals direct. Sometimes he has to use a different agent, and he'll never sign this unless I limit it or unless we kind of agree to something else. I said, well, then limit it. Just have a process. Say, look, if you don't want to sign my plan A, then every time we do a showing, I'm going to send you a new one of these. It's a little more work, but I'm happy to do it. I don't have a problem. This particular customer that they were talking about is a customer of mine as well. And yeah, he's incredibly sophisticated, but he buys a lot of properties. He sells a lot of properties. He's a great client. I think it's worth the extra effort to do individual buyer brokerage agreements. And it's a little more work. All right, so Dad, we looked at this. After we finished this one, I want to go over your idea about the $100 thing. So number 6, the FAR form does have a retainer. Here's my advice on retainers. The time you'll use it the most is when it's a kind of a cold call, random referral. It is someone you don't know. It's not someone that was referred to you, but maybe they found you through the internet or some sort of random cold call. Retainers are great for that. They really are. Hey, I'm going to spend all day Saturday with you, so I'm going to ask for $250 just to cover my costs. And if it doesn't work out, that's fine. That's okay, but at least covers my costs, and we didn't waste our time. I
Yeah.
think it's a good thing also, Dad, because it kind of, you get to determine, is this guy for real, or is he just
Yeah,
wanting to use my
I
time?
I like it. I'd pick a weekend fee that you would charge people that if you're gonna
Yeah,
spend a whole weekend with somebody you don't know, and it gives you an opportunity to build trust and get to know them and how
yeah.
serious they are. And do you even want to work with this person? They could be serious, but they could be a living nightmare, and you might not want to work with them. You
Yeah,
just
it
may not
gives
get
you
along.
something to say. You mentioned it, Dad, like a set weekend fee. I think that's awesome
You know?
because you come up with it. You say, "Hey, I'd love to see these properties on Saturday." Say, "Great, my fee is $250 a day. Well, I'll send you the document now. We can collect it later. No big deal." Um, and if they
We'll
give
do
you,
whatever
if
you
they give you,
want for a whole
yeah.
weekend, 500
If
bucks.
they
That's
push back, that's more information for you. Hey, this guy won't even pay the retainer. He's giving me a hard time. Is he for real? Do I really want to cancel my other plans to go show property for this person?
yeah.
Gives
And
you
you got
information.
children maybe, and you're not
Yeah,
abandoning them for less than
not
X.
abandoning them. Absolutely. Number 7, you are going to have to put in, this is where your compensation would be. Keep in mind, most people in town have a transaction fee with their brokerage. You do need to include that. It is compensation. It is compensation to the broker. You do need to include it because if you don't, you can't ask for it later. You would have to get everything amended again. And I think that could be a potential problem. Denise asked for retainer. They pay up front then, or do you write the check
Yeah.
out to the broker or us? What do you think, Dad?
They pay up front and it's payable to the broker.
Yeah, this is totally up to you guys. I think as long as it's in writing, you might be willing to accept it later. Or you might be willing to say, hey, look, this is going to be great. We had an awesome day Saturday. I'm not gonna worry about the retainer. We'll just get a commission when we close on the property, just like we talked about. Like, I think getting it in writing is the key. If you want the money, find a simple way to do it. PayPal, Venmo, Zelle, a check would be
Yeah.
fine, obviously. Actually, so I'm getting ahead of myself. That
If you
fee
really
does need
want
to be
it
made.
up front, if they're paying later, you got to be willing to let it go
You
because
have to
it's
be
not.
willing to let it go. Yeah. Part of your business. It does need to be payable to the broker. So I apologize, kind of got a little ahead of myself. So all these fees are payable to the broker. They are compensation. It would be made payable to your broker, and then your broker would pay you out when the transaction's completed or whatever their policy may or may not be. Why would a buyer, or maybe I'll get to Deb's question next. So you can put something in here. You again have a protection period, conditional termination. So I don't like the conditional termination language. This basically says if the broker agrees to terminate this buyer brokerage agreement, we will charge, if we allow it, we will charge you $5,000. I would rather leave it blank. I would put it at 0. Wouldn't make it an issue to the buyer. I don't want to freak them out because the broker still has to agree to the termination. That's when you could come up with the number. So I wouldn't do it now. I would do it later if that ever became a thing. Does that make any sense, Dad?
No, it makes sense. Perfect sense, Christian.
Yeah, I think this could get you in a little bit of trouble. That's a conversation you don't need to have. It's not relevant. Dispute resolution, what happens if we're in disagreement? Do we go to arbitration or whatever it may be? And then everyone signs it. Again, check the requirements. Is your broker going to allow you to sign it, or are you going to have to get the broker to assign it? Every broker is different about it. Dad, can you talk to me about your idea on the $100? Let's say we use this form because Christian says it's our plan A, it's the best form we've got. How does the $100 come into play?
Well, I'm looking at two things. One, basic contract law, you have to have mutual consideration in order to be a valid contract under the law. And the other one is the workaround language in the settlement agreement. So both of those bother me. You need to have something, and there's some point in basic contract law where a judge will say, that dollar is illusory, it means nothing, so you have no consideration flowing both ways, and therefore you never had a contract.
So do you think that an agent really shouldn't put some sort of nominal amount, that they should If you're gonna do it right.
Yeah, if you're gonna do it right, have,
And then maybe a plan B would
have
use,
your fee, whatever it is, if they're gonna write you a check, great. If you're somebody like yourself, married, 4 kids, what's your weekend fee? Because, taking away time from your family is a real, inconvenience.
yeah.
Are they real
So
or not?
yeah, I
Like
agree with you,
your
Dad.
grandfather would go around looking at properties all weekend long with no intention of buying anything. He just liked looking at property.
Yeah,
So you want to get rid of people's like your grandfather, no offense
that's
to
right. He's a
the
lot of
living.
fun to talk to, but he's my
Yeah,
grandfather, not yours. So yeah, I would say plan A, exclusive buyer brokerage agreement with your fee included. Plan B, something like the property pre-touring agreement, which is you can explain to a buyer is not an obligation. It can be terminated by the buyer without issue. And again, I would put what you charge, and then you can always amend your buyer brokerage agreement later. In fact, the NABOR has one of these amendment to buyer broker agreement. You'd still have to put in some language, and basically what I would do on these is I take what I'm changing and say for each property purchased by buyer, percentage of this, or I'd say section 5 is modified as follows, or commission shall, or not commission, compensation shall be X%. That's how you would amend it. You're welcome to call us or email us and we'll help you with language. But plan A, exclusive buyer brokerage agreement. Plan B would be the property pre-touring agreement or something like that, because you do want the buyer to be obligated to you. So you do all that before you show the property. Dad, what does it mean to show the property?
well, it has to be working with and show the property. It could be Zoom, it could be physical showing, it could be driving by and looking at it from the street. You don't have to enter the house. It's extremely broad. But if I may go off point for a second, we've been going over this for a couple of weeks, and I keep hearing my father's voice in my head. I strongly believe that people should go with their top fee up front. My father would say, if you don't ask, you don't get. I mean, you have nothing to lose by asking for your standard fee. And not to toot my deceased father's horn, but he was a #1 agent with Deltona and a top realtor Marco for years and years and years. So he was not shy in going right in for his top dollar. I mean, let the client be the one start whittling away at it. Don't whittle away at it yourself.
Yeah, you learned that in your own business, Dad, where
Oh
you
God, yeah. I mean, I for years would, if I got a big closing and it was, a very large title insurance fee, I would give a discount without being asked, thinking I was being very clever. And then for giggles, maybe 10, 15 years ago, I said, let's try what happens if I stop doing that. And I got next to no blowback. I might get 1 or 2 clients a year out of 1,200, 1,300 people who would question the fee. And I'm like, what an idiot. I should have listened to my father and just go with my fee and let them be the one to raise the issue of, gee, that's too much first.
see that there are not many attorneys that call themselves idiots. So there you
No,
go.
but I
It's
I
on
grew up
video, it's
with my
recorded.
dad.
I'm
If
gonna
you're
be
shy,
playing this at your retirement party, I promise you that.
no, I learned from it.
All right, so again, the NAR FAQs are very helpful with this. What number is this? 57. What does it mean to be working with buyers and it's triggered by touring a home? What does it mean to be working with a buyer? Working with language is intended to distinguish MLS participants who provide broker services to a buyer, such as identifying potential properties, arranging for buyer to tour, performing facilitating negotiations on behalf of buyer, presenting offers by a buyer, or other services for the buyer. That is what it means to be working with a buyer, talking with them, going to dinner with them, understanding their needs. That's not necessarily up to the standard of working with a buyer. So that is what working with. If a participant is working only as an agent or a sub-agent of the seller, then participant is not working with the buyer. So this is another really interesting part. If you are the listing agent, You can talk to the buyer, you can help them because you're actually working for the seller. You're trying to sell this property. So you're not forming any sort of buyer relationship just by talking and working with this buyer because you already work with the seller. I think that part is really interesting. I've talked about that a couple of times. A written agreement is required prior to a buyer touring a home. An MLS participant working with a buyer can enter into a written agreement at any point, but must do so no later than prior to the buyer touring a home, unless state law requires written buyer agreement earlier. What does it mean to tour a home? Look at that. Means when the buyer or participant or other agent at the direction of the MLS participant working with the buyer enter the house. So if you enter the house for a buyer, that is touring the property. This includes when the MLS participant or other agent at the direction working with the buyer enters the home to provide a live virtual tour to a buyer not physically present. Yeah, and so here's the tricky part. You don't want to be tattletaled on. That would not be okay. You know, if you are going to be entering a home with a specific upon a specific buyer's request, I think you need a buyer brokerage agreement. If you're entering the home because you think a buyer might like this property, but you haven't talked to them about it and they didn't ask you to go, maybe that's not showing them the home. There's a little gray line there. I don't know. I'd say get the buyer brokerage agreement. Again, plan A, buyer brokerage agreement, exclusive. Plan B, pre-touring agreement. That one works too. Talk to your broker about
open houses. Working an open house doesn't fall in this category either.
working an open house, working for the seller, listing a property. None of those things would be working with a buyer. Deb asked a question, related or not, why would a buyer sign a buyer brokerage agreement or a seller sign a listing agreement with the term agreement 180 days versus 60 days? All right, it's a good question. I don't know if I'm going to answer it correctly or not, but most listing agreements, I think the default on the listing agreements was always 9 months. And that's the NABOR listing agreement was always 9 months. Well, we changed it. I am on the NABOR Forms Committee. It was changed to 365 days, I believe, a full 12 months. So if you don't put a number, that listing agreement is good for 12 months. I think they did that to benefit you. They wanted the realtor to have a way to say, hey, the default is 12 months, as opposed to if you had a listing agreement for only 60 days, that's not so great, right? That really puts you under pressure. You're going to do a lot of work and you got to catch lightning in a bottle. I think a buyer broker agreement is the same thing. If you can get more, that's plan A, but plan B, a shorter commitment, 1 week. 1 day is fine, but it does need to be enough to cover the buyer when you actually make an offer. It's
Again,
a business decision.
You don't get, so go start with the top number.
You don't get what you don't ask for. Exactly. Terry, hi Terry. In number 8, it says property called to attention by broker. Does this include sending automated emails or property listings from MLS? I don't believe so. It doesn't meet the terms of touring, just sending them listings. I don't think that's sufficient. But yeah, I think you've got to have some reasonableness test there. Again, you may want to talk to your broker if you're worried about that. I mean, ultimately, we are responsible for our own actions. So if you want to be extra careful, plan A, get a buyer brokerage agreement. Plan B, pre-property touring agreement. Plan C, don't do anything and take the risk. You can see it's tough. This is a really tough position for us because I'd love to just tell you, but every broker is dealing with it differently. Let's see, what if a buyer signs these with multiple agents? Does the first one, earliest dated, take precedence? What if the buyer sees the same property with multiple agents and makes an offer with another agent, but you had an agreement and also showed the property? Yeah, so I think we've talked about it before. If not, this is a great question. They can sign as many as they want. They're just going to be paying a lot in commissions.
Yes.
It's like hiring multiple attorneys. You can hire as many attorneys as you want. I don't care if you hire me and my dad. Just make sure you're paying both of us. Or at the very least, make sure you're paying me. Right, Dad?
Thank you, Christian. Thanks for thinking of me.
You got it. At least we're paying us. We're okay with it. But yeah, I think it's the same way. I think it's it would be a violation of your exclusive buyer brokerage agreement. In fact, I believe it says in here that the buyer agrees to work exclusively with broker. So the buyer would be in default, and I would point it out to him and say, hey, you're not working with anyone else. You haven't signed one of these with anyone else, correct? Because you can point out number 3, it's right there. Don't do that. But if they did, so be it. As long as your contract is right, you can enforce it. Can you mix and match FAR/BAR forms with NABOR? Yes, but Dad, what's your general advice on mixing forms?
Check with us first. I mean, the buyer broker agreements, you and I have already looked at them. None of them make specific reference to either FAR/BAR, FAR, or NABOR paragraphs, terms that would create a conflict within the document itself. Therefore, in that particular case, those are interchangeable. Not all the addenda with NABOR, not all the addenda with any of the other forms. You can do that without first looking at it. For example, we have defective repair items in NABOR. They have general repair items in FAR/BAR. It's different. So you got to be careful. It's not referring to specific parts of the sales contract.
Yeah, so you have to just be careful. That's the general advice. With regard to buyer brokerage agreements, listing agreements, seller disclosures, you can mix and match. You can. There's no problem mixing and match those forms. So I actually had this question yesterday, Dad, and they said it's a Lee County property. So I know they're going to want a FAR/BAR contract, but I'm used to using the NABOR. Can I just use the NABOR buyer broker agreement? Absolutely. Absolutely. That NABOR agreement is between you and your buyer or your customer. It has nothing to do with where the property is.
Disclosure, Christian?
That's the exclusive buyer brokerage agreement.
Okay.
Yeah, so exclusive buyer brokerage agreement, even the listing agreement, mix and match. It doesn't, you could use a NABOR listing agreement for a Lee County property that has Lee County riders for, you know, the HOA or the condo or the FAR seller disclosure. You could do that, no problem. It's going to look a little messy. One of the things that kind of drives me crazy is when I see an attorney who has, you know, form 1 is Times New Roman, their second form is Arial, and their third form is, you know, something else, you know, Georgia or whatever. And that drives me crazy. One is font 11, one's font 13, this one's bolded, this one's highlighted, it has a different margin. That, oh, it drives me crazy. So your buyer might think it's a little weird, but you could certainly do it. Absolutely. Absolutely. All right. So Douglas asked a great question. You mentioned additional fees in the buyer broker agreement means all fees charged. What about the broker fees that are charged at closing that are called processing fees? That is compensation. It does need to be in those agreements. Even though the agent is not accepting those fees, doesn't mean that it's not compensation. It is. It is absolutely compensation. So it needs to be in there. And that might be something that people learn the hard way, unfortunately. You know, there's a lot that brokers are learning about this. I was talking with a broker yesterday, and they have a plan in place, and they're going to do this. And if you don't have your forms in, then we will not pay your compensation. And I brought up, I said, well, are you going to be accepting the compensation? And they hesitated, and they're like, what do you mean? I said, well, you're the one accepting the compensation. It's not the licensee that's accepting it. So if you accept, if you deposit that check and you don't have all the paperwork, the broker is in real hot water and they're going to blame you for it. So just because you guys are getting the bulk of it, I hope, hopefully you're getting the bulk of the commission or the compensation, doesn't mean the broker's not taking the same amount of risk. So they need to be very, very careful that if they're going to collect a fee, it's in the buyer brokerage agreement, it's in the listing agreement.
I mean, technically the compensation is the broker's, just like the listing agreement belongs to the broker. Everything flows through the broker.
Yes, everything flows through the broker. You just have a separate agreement with your broker on how much you are owed. Lori asks, as an example, if someone calls to schedule a showing and you prepare the agreement for a single individual and a husband and wife come to the showing, I would think you need both parties to sign the agreement, as you do not know how to take title. Might be a good idea to keep a blank form on hand. Lori, it's a great question. We've tried talking about this before. I can't remember if it was 2 weeks ago. It is a thing. Imagine there's a buyer, they give you their names. Let's say they give you the husband and wife, but then when they make the offer, they want to put it in a trust, or they want to take the offer in an LLC. Do you need to change your agreement? Maybe we could do an amendment. So Lori, what I would suggest is, if you have that signed in advance, you're fine. Show them the property, have fun with it, make sure that they fall in love with it. And when they go to make an offer, just amend that buyer broker agreement to match the offer. That's what I would do. I wouldn't overthink it, keep it simple. In fact, you probably would be okay not even changing the buyer broker agreement at all. I just don't want to give you that advice. Just do an amendment.
Well, and you can take it a step further, even though, say, the husband signs the contract. I mean, by the time you close, he may very well have his wife on the deed, or be in a revocable trust or some other entity. So, we can't keep changing things.
Yeah, exactly. I wouldn't overcomplicate it. Keep it simple as much as possible.
Yes.
Douglas, as you mentioned, oh, he already did that one. All right, we're good there. Christina had another great question. I wonder if brokers will charge fees for retainers collected by agents. I sure wish we could use Venmo. Wonder if that'll ever change. Yes and no. So the one thing that won't change is that the only way you're allowed to make money on these deals is because you have a license through the state of Florida. That is the only way I am allowed to pay you. If I found out right before closing that you're not a licensed agent, or that the broker lost their license, guess what? I can't pay you. Not going to happen. So you cannot accept any sort of compensation for showing property, for buying property, for selling property, unless it is paid to the broker per Florida law. I don't know if it's a misdemeanor or a felony, but it's, it would be bad. So I do think that part will never change. But the other part, I think brokers, as they get used to this, if they find that retainers are more and more prevalent, they will make it easier for people to pay it. They will make it faster. There might be a fee, a processing fee, or they might just hold it until the buyer brokerage agreement either expires or the closing closes, because it is like a credit towards future compensation. So it is clunky, and there's nothing you can do about it.
I think it depends too on the amount of work involved. If it's going to create a lot of work for the staff of whatever brokerage you're with, they got to pay the staff somehow.
So now we've got our buyer brokerage agreement / pre-property touring agreement all signed. We start going and looking at properties. One thing I want to point out, someone mentioned, hey, I've got 13 showings lined up on Saturday. We're going to go look at all of them. Am I going to call every listing agent, and ask them what they are offering? I mean, you can. What do you think, Dad?
You're not going to get them. I mean, I don't get every agent when I call them.
Yeah.
A lot of them
I think that's a great idea. Maybe that's your plan A. I think you'll quickly go to plan B, which is state your price. You don't get what you don't ask for. And you tell your buyer, hey, if there's additional compensation being offered by the listing agent, we'll do a modification to the buyer brokerage agreement at that time. So if it was 3, we'll go up to 4. If it was 2, we'll go to 3. Don't cut yourself short. Don't do too low and then modify it later, but just put your fee. And then if the agent is offering more, then go back to the buyer and say, as we talked, this agent is offering more. Again, you're still not paying anything. It'll all get paid. And you do a modification. I think that's how it'll work. I don't know if that is going to work, 3 years from now. I don't know how much this industry will change, but that is how people are going to treat it initially. I don't think I would do individual buyer brokerage agreements for each one of the properties. I think that's too much work, personally. Let's see. Christine says, can we leave a banana on our voicemails and say, if you're calling in regards to such and such, blah, 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 blah. Yes. per the NAR settlement, you could talk about bananas on your voicemail. That wouldn't be a problem. That's a inside joke, but yeah, you could put compensation listed for a property. You could have some sort of automated voicemail. If you're calling about the property on Mainsail, please push 1, and then you say, we are offering up to 3% or whatever, 10 bananas. You could do that. Yeah, you could do that. Will brokers do that? I don't know. All the brokers are looking at what's realistic and what can get agents to come on board, right? So even if it's not realistic, but agents will sign up because of it, they'll do it. I just don't know if it means much for you. I made the analogy, if you guys have ever been car shopping and they have those paddle shifters. Dad, this is your story, actually. I stole it a little
I
bit.
have paddle shifters in my
You
car.
remember
and
you remember
use
the
it.
first car you ever had paddle shifters on? I think it was the Volvo. It was
Yeah.
the white or blue Volvo and it had paddle shifters. I
That's the
remember
one you cleaned for me when you were a kid? Yeah, I
I
remember that.
remember it. I was paying attention. That was the only time I ever saw you use them, was on the test drive. So some of this stuff is going to be that sort of analogy where it's like you're only using that on the test drive, but in real practice, when you're just driving the car, you're not going to use things like that. You're not going to be updating your voicemail every week. You're not going to be updating your website, and maybe you are, maybe you're better at it than I am. But I'd rather just focus on selling. And if someone calls me, I'll tell them. Or if they call me, I'll say, hey, we're open to it, just include it in your offer. I've always liked that the best.
And be
Right,
careful
so
of up to language, because they do that on TV with almost anything they sell. You're gonna deal with up to, and up to could be $1.
yeah, or a range or any of that stuff. All right, so we have our buyer under contract with us. And now we start looking at properties. How do we put together the offer? Maybe we called the listing agent and they told us the amount. Maybe they didn't answer the phone. How do I put the offer together? That's what matters. We're gonna go over this super quick because you guys are good at it. Number 1 is a sales contract. Just the same way, really, sales contracts have not been changed just yet. They will change because there are other things that need to be done. But right now, the NABOR sales contract is the same that it's always been. You'll put that in there. And then you will have your compensation agreement. And I'm going to share my screen one more time, maybe 2 more times. This is a compensation agreement. There are several options. There are 2 with NABOR, 2 with FAR. There might be 2 with NABOR. There are definitely 2 with FAR. And so they're just simply called compensation agreement. This one is the seller to buyer's broker. Now, I like the forms, but you always have the option of putting it in other terms and conditions. Seller shall pay, such and such brokerage, 3% as compensation. You could do that, and you'd want to get it run by your broker, make sure that it's approved, make sure you're not writing up language that isn't approved. But if you don't want to ask your broker, do it this way. Use the form, fill in the address, put in the term, and how much you're asking the seller to pay. So even if the listing agent had only, offered 3%, if you wanted 4, put it in here. Your buyer will sign it, will ask for it. It's fine. I don't have, your buyer's going to have to sign a modification, or you're going to have to make sure their buyer broker agreement says the amount that you're asking for. But you put your amount in there. You have everyone initial, sign it. Seller is now obligated to pay your broker a certain percent if the deal closes. I like that. I like forms. They're good. So you got your sales contract, you got compensation agreement. I think, so NABOR has, what do they call it? Broker compensation agreement. It's the same thing. It's 1 page. This is not with your buyer. This is from one broker to the other, guaranteeing payment. This is what MLS used to be able to do for you. If you listed a certain percentage on MLS, the other agent could rely on it. And you guys could go through, mediation over it, or go in front of a hearing at NABOR or wherever association is. We don't have that anymore. This has to be included. Dad, I have a question.
Yeah.
We've got, this is all new, and brokers are dealing with it in different ways. I heard one broker say, you can just rely on my email. We're agreeing to pay you 3%. You can rely on this email. We will not sign this. I don't like that. What do you think?
I don't like it either. You have to argue the Electronic Signatures Act, which is spotty in this state. You know, some districts enforce it, some don't. I would rather have the agent have the authority to sign the thing.
Yeah, I think it needs to be signed. You probably have an argument if you have it in an email. I don't want to argue. I want it signed. I would
It's
like
not
it signed. And in this case, the agents are signing it, but the in the FAR one, they have one where the seller signs it. So that's even better. You know, would if the seller was just saying in an email, "Hey, I'll pay you 3%," would you rely on that? I
No.
wouldn't. I don't think I would. You
Unless
asked, can
them
we?
really well. No.
I'm trying to think, Ewa, I don't know exactly what your question is. As a listing agent, can we have this form inside the property or included in the brochure? I think I know what you mean. Okay. So could you pre-populate this? And I have seen agents trying to do this. They'll fill this out, they'll put the amount, and they'll have the listing broker sign it in advance. They won't specify who the buyer's broker is because it could be any broker, but they will leave it at the house. And if you want to make an offer, you take this form, it's already signed by the listing broker, it already has the amount stated, and then your broker would just sign it to be on the other side. Yes, I do think you can do that, but be careful. Do not upload this on MLS. That would be an NAR violation. Do not do that. If you go this route, great. That I've seen people doing it. I really have, but whether
I
your
really
broker
like
will
the
sign
idea.
it or not, I don't know.
I mean, I think, you know, if you bring your buyer to the house and it's already pre-signed, that buyer can see that the seller is actually paying the commission, so it makes it 1,000 times easier.
Yeah, exactly. Lisa asked, does this need to be included as an addendum to the sales contract? It does if it is the one where the seller is agreeing to pay. I think you should check the box as an addenda. I think that should be plan A no matter what, is that you include it as an attachment. No matter what, that's your plan A. Is there a plan B where, okay, I forgot to attach it? As long as it's fully signed, you're probably okay. But that's plan B. Maybe it's a plan C. Just attach it. I think thank you for pointing that out, Lisa. I think that's great.
Well, people tend to net out fees anyway, so if they see that there is a buyer broker's agreement, the seller won't be too offended over what the buyer might offer.
Yeah,
They'll do the same mental math they're doing right now.
totally. So I lied to everybody. I said it was going to be the last screen share, but I have another one for you. I've been accused of not going over the listing agreement, so let's do that. This is the updated listing agreement. This one was updated just this month or last month, July 12th. This is the NABOR one. FAR has one as well. And it's pretty darn similar. Pretty similar. They've changed a couple of words. You know, they no longer talk about cooperating brokers. They just call it a buyer's broker. But if we go down to the compensation part, that's where the fun really begins. So a listing agent will put the total commission that the seller is paying right here on line 128, the total amount. So if it's 5%, now I'm not a realtor, so I can say percentages and not get in trouble. It's 5%, I'm going to put that on 128. 6%, I'm going to put that on 128. And then separately, I would check this box, elects to permit broker to offer a share of the portion of the commission or compensation with a buyer broker who has procured the buyer. I love this language, elects to permit broker. So you're permitted to give up to a certain amount. And you would put that here. So if it's 6 and you're willing to share up to half of that, you'd put 3 right there. So here's the part that I think is interesting. If the buyer's broker only asks for 2, what happens to the other 1%? So I was going to take 3, I was going to offer 3, but they only asked for 2.
Keep 4.
What happens to the extra 1? You got 4.
Yeah,
you could give it back to your seller if you wanted. But
there's no mandate. I mean, you can keep the whole darn thing.
I think you can. I would probably bring that up to a seller somehow. I wouldn't want to surprise them with that information. But I would say, hey, if I'm able to procure a buyer without paying the full 3%, then I would take the difference. I need you to understand that. Okay. If the
And,
seller's
and,
gonna fight you on it, you want them to fight you on it now, not at closing.
in plain
Someone told
English,
me,
my fee is 6%, and you give me permission to share part of it if I feel
Yeah.
like it.
if I feel like it. Now, this could get tricky if you think the listing agent is not telling you the whole truth. So if you're calling those listing agents and they're telling you, oh, I'm only offering 2, it's possible the seller has given them permission to offer up to 3. You just don't know it. So will you still want to call the listing agent? I don't know. I think it's more important to just talk with your buyer, get the most you can with them, and make sure that you're providing the right services and just be happy with it. Alternatively, line 145 does not elect to permit broker to offer a portion of the compensation. This would be similar as if you put 0 on line 142. So you could put 0 on 142, or you could check the box on 145. I would say that's a red flag if a seller's like, no way, I'll never pay commission. I don't know. I think it's valuable to have you guys involved. I think it's valuable to have a buyer broker involved, and we need to encourage that. And if a seller's going to sabotage that, be careful. Be careful. Separately, concessions. Now, our local MLS does not offer a field for concessions, aka a credit of some sort. I don't know if people are going to use this or not. I would say in markets where MLS is allowing concessions on MLS, you'll use this. And it's great. It would be an awesome field if the local MLSs used it. But because they don't use it, maybe you just don't use it either. I think it's almost like it's a dead zone. What do you think of that, Deb?
I agree with you. I mean, I keep thinking of what the lenders are doing here, and that's the standard language we always use to cover up repair credits to get deals closed. So I don't really like that, to be honest.
Yeah, I agree.
And
It's
the
not
settlement
real
agreement,
terms.
it picks on concessions that go exclusively to compensation to the realtor. So that's going to be an area that's going to be looked at very closely by plaintiff's lawyer, Department of Justice, and so forth.
Yeah, which amount may be used towards the payment of compensation to a buyer's broker. So if your seller says, hey, I don't want to offer compensation exclusively for a buyer broker, I'd like to make it more open-ended and allow the buyer to, pay closing costs and or pay their broker commission. Maybe that's how you would use it, but you still can't really put it in MLS. So how helpful is it? Let's see if there's anything else that really jumps off the page.
It's not an MLS.
The rest of this is pretty straightforward. To keep in mind, everyone gave a hard time about that default language in the buyer brokerage agreement.
It's always
The
been
listing
there.
agreement has the same language. So sellers have been signing these for decades and never objecting to
I think
it.
it's the same since I came here, Christian. I
Yeah,
don't remember.
it's the same language. I mean, honestly, if a buyer were to fight me on it and say, it is the same language in the listing agreement, it mirrors almost word for word. So you kind of take the wind out of their sail if you say it that way. A good warning, wire fraud is still rampant. Holy moly, it is bad. So be careful. Mike makes a final point. I know this is a longer video, but I think it's been really a great one. Mike makes a great point. Given the separate seller to broker and broker to broker forms, as a buyer's agent, I would imagine we need to make sure and specify who is supplying the buyer broker compensation, not simply asking how much is being offered, but by whom it will be paid by. That's a great idea, Mike. It's awesome. It is confusing because I could set this up where the seller has only agreed to pay 3% total commission, but then when you made your offer, you had the seller give an additional on top of that. Yeah, you could do that. So yes, if you do call the listing agent, you're going to need to ask them, hey, when I fill out the compensation agreement, and am I doing that from your broker, or am I asking for that money to be paid from the seller directly? So that does matter. That's a really good point, Mike. And again, if you can't get them on the phone before you make your offer, you're going to have to guess. you're gonna have a choice. Do I use the one where it's broker to broker, or do you use the one where it's seller to broker? Do you have a preference, Dad? I was thinking about this, who I would want to be obligating to paying my compensation if I was the buyer's broker.
I
Who's
like
better?
the broker. I think just psychologically it might go down better with the buyer, but that's just my opinion. I could be
Yeah, I
wrong.
mean, there's the benefit there is that both of the brokers are bound by NAR Code of Ethics. They're bound by, arbitration within, the association, the local association. So there are definitely a lot of upsides where you don't have to spend a bunch of money on attorneys and all that. But outside of those upsides, having the seller agree and then him stiffing you, I could put a lien on your house. I could sue you for damages. I mean, there's so much there. I don't know.
That language here in the early 80s when I got here, I mean, I'd get
Yeah.
one or two people a year who complain about it. That's really it. And people net out fees anyway. So if we can come up with some way where we can make this very simple for the buyer, that this has been going on in a different form forever.
Yeah.
It's going to affect how much the buyer is willing to offer, like it always has. It's affected how much the seller is willing to accept.
Yeah, I agree. Mike finishes, he says, wouldn't it depend on what the listing agreement says? Yes, it does, Mike. And so I think they'll just counter. So if you asked for the seller to pay the commission, and now they're looking at your offer and they're like, hey, we're going to come back, we're going to make it so that it's coming from the broker. That's fine. They're probably going to be countering on one or two things anyways. So I think you just have a go-to, have it broker to broker, especially if you're using neighbor forms, it's already broker to broker. So that should be your go-to, that's your plan A. And then when they counter, they can tell you, hey, this actually has to come from the seller. Okay, that's fine. Just send the form, we'll sign it. We'll see. Here, to finish it up, do you advocate being a single agent over transactional when representing buyers? Do you have an opinion on that, Dad? I think that's his opinion.
I don't
Yeah.
single agent, you have a duty of loyalty and obedience. That rubs me the wrong way.
Yeah, it's a pretty high standard. Yeah,
It's more than I owe your mother, so I don't like it.
yeah. Yeah, I would say transactional is your plan A. But if a seller or buyer says, hey, I don't like that you're not working exclusively for me when I have to work exclusively with you, we say, that's fine. Why don't we switch this to single agent? I have a higher level of duty. Let's go over what that means. Obviously, you should do your research and make sure you're okay with it, but that would be my plan B. So I guess to answer your question, my preference would be transactional, and then I would use single agent if that is what the customer demanded.
Well, the additional benefit too is you could sell the property to another one of your clients, or customers, as they call it.
Yeah, so if you were single agent listing side,
You'd have a
there would be a conflict and you really couldn't help the buyer at all.
If you had two people who are interested in the same property, you'd have a real problem because you have a duty of obedience to the single agent customer.
So smart, so smart. All right, guys, that was fun. I hope that was, specific enough. I think, if you want to look back over the last 4 or 5 weeks, we've done a lot of these videos, and sometimes they're more theoretical. I haven't done a ton of like going through the individual lines. Like I said, Sean Gary's video on NABOR does a really good job of that. If you want to really know the forms, read them first, watch one of those videos or go to a class like that, ask questions, and then start using it. My brain is best thinking about how to use it, the practical nature, the strategy, thinking what is the buyer or the seller going to combat with? How are they going to fight me on this? What would my response be? So I think that's what I'm better at, Dad. You're excellent at it. We've spent a lot of time on this. We are going to have a very special video next week. So Nick Bobzien, former NABOR president and a fantastic realtor, he's going to come on next week. We're going to do an on-site video if it's not raining. We're going to do an on-site video about what it's been like right before the August 17th change comes. And I think it'll be a pretty cool one. And I'm going to try not to talk. I'm going to let Nick talk. I'm going to let him answer questions, how he's doing it, the pushback he gets. I think he's got a great mentality about how to just approach something and have confidence, and how to be a great salesman. He does an awesome job. How long have you known Nick, Dad?
Since he came to Collier County, since
So
he started
20
dating his,
years, 15 years, something like
I
that.
met him when he was dating his first wife, his only
Yeah,
wife.
he's a wonderful guy. Wonderful
Yeah,
guy.
if I
All
might
right,
make a
everybody.
request here before we cut, if we could
Yeah.
get feedback from realtors on what's working for them, because this is all new for all of us.
Yeah.
What presentations, what forms, what kind of blowback they're getting from their buyers, if any. That'd be very useful to us to give better advice to you. So
Yeah, it
share
is
your experience.
hard to spend so much time with everybody and go over this. It has been very draining, but every time I talk to someone, it enlightens me to a different perspective, a different way of doing it, another concern or another solution. It is wonderful. So keep reaching out, keep going. If you're confused, I'm probably confused. If you think it's simple, then please teach me.
Yes.
We'll figure it out together. If you haven't subscribed to our videos on YouTube, it is youtube.com/Christian Ross. There's over 155 videos on there, and you get a lot of this. Bye, guys. Good luck. Thanks, Dad.